Good afternoon. I'm Daryl Manhart, and I represent the Appleys, Lindahl, and Havens. And I guess since my adversary started with Sabin, I'll start with that as well. I think it highlights, or allows me to highlight, that the claim that the Stasinskis have presented, while wrapped in the rhetoric here of marketability of title, is not in fact one for marketability of title. If you take a look at the phrase there, marketability of title, he's really emphasizing marketability, and he's not getting the point of this is an issue that has to do with title, not the marketability of the property itself. And for instance, if you look at, if you allow me to cite some secondary authority, Amjur second, vendor and purchaser, section 103, which is the first of like 40 sections, all entitled, I forget the title, it's what constitutes good or marketable title. The very first sentence of section 103 is marketability of title is concerned with impairments on title to a property, i.e. the right to unencumbered ownership and possession. So marketability has to do with ownership and possession. And if I can jump to the last sentence of that same section, 103, I want to quote the last sentence. There is a difference between economic lack of marketability, which concerns conditions that affect the use of land, and title marketability, which relates to defects affecting legally recognized rights and incidents of ownership. And there's a footnote for that. It cites a 2002 California case and a 2004 Massachusetts case, both of which include citations to other opinions to that same effect. And what the Stasinskis argue here is that what they're not arguing, which would be a marketability of title, is that there have been any other claimants to ownership or possession of the 431-acre parcel, the 10-acre parcel, or the 13-acre parcel. They're talking about something else, what their perceived economic marketability or utility of the property, which is not having to do with ownership and possession of the three parcels. And I'll borrow from Mr. Stasinski's counsel's own brief, which cites to volume 17 of Williston on contracts several times, including section 50:10, where he has lifted various sentences out of that section in his brief. But if you look at the cases footnoting that same section, it includes the same California case and Massachusetts case that are referenced in the Amjur site, and various others which also make that same distinction, noting that one can have marketable title while the land itself is valueless. There's a reference to a 2011 Vermont case that describes the rule as this way: marketable title is a title that will enable the purchaser to hold the land purchased free from the probable claim of another. The Stasinskis have never come before a court and said someone else is claiming the right to ownership or possession of any of the three parcels.
Let me ask you about Sabin, because I understand everything you've said, but the Supreme Court went on to say that such a title, and the such a title referring to marketable title, must appear of record to be marketable.
Yes, Your Honor.
So what do we make of that?
That's completely consistent, Your Honor. I'd emphasize those last words, of record. And if you look at what's going on in the Sabin case, you started to recite some of the facts yourself earlier. The court is dealing all with things that are of record. They appear to be contracts of sale with a few deeds interspersed in there. So the court was looking at a series where it went from, I think, Stone to Hill. I'm going to miss some names, Ray. Yeah. Okay. Yeah. Thank you.
Don't explain it. That's okay.
Okay. But the part I want to would explain, though, is within that chain you have, when you get to the end, whichever one was the plaintiff, Sabin or Rausch, looks back and says, well, in here there's a quick, or not, sorry, I mean, there are deeds to two other people that while they say they're subject to these other contracts, I'm not sure about whether I've got marketable title. Those are all of record. Mm-hmm. Those all have to do with the rights of ownership and possession of the particular parcel of land there. If you look at the deeds here, the deed for the parcels the Lindahls conveyed and the deed for the parcel the Havens conveyed, the first one lists the 431-acre parcel by legal description and the 10-acre parcel by legal description. It does not list, it does not convey with a warranty of title the easement. Same for the Havens property. It conveys by a legal description of the 13-acre parcel, and I don't want to presume the level of experience with real estate transactions, but you may have seen, I have seen where sometimes people convey, it'll be a parcel, a third, let's say another parcel that lists an easement in and list a legal description for that. You could give a warranty deed as to an easement, but there isn't one here. So the Stasinskis are arguing marketability of title when there's no title claim against the 3 parcels that they acquired by deed. They're arguing that we think we got something that's less useful to us than we thought, and that's not covered by their warranties under their deed. They have title and possessory rights to all 3 parcels.
You know, I'm not sure I'm fully comfortable with that argument. It was, and maybe my understanding of the marketable title is too basic, but it was my understanding that marketable title is really just simply the ability of the owner to convey the title, the property, to the next person without having an impediment dealing with the title that would interfere with that alienability of the property. And I thought that's what Sabin and other Arizona cases recognize in talking about marketable title. Am I wrong? Right?
I'm not sure. I'm sorry, I was nodding my head, but I don't actually see the difference in what I said and what you said.
Well, okay, so let's assume that we're on the same length then. Then the question is, how should marketable title be memorialized? Now, Sabin dealt with a situation where the clouds on the title were of record. Here, the potential impediment to marketability is access, or lack thereof, arguably. And here, there was a prescriptive easement that came into existence through adverse possession back starting in about 1953. Okay. That prescriptive easement is not recorded. Well, put aside the deed. But that prescriptive easement, adverse possession, is normally something that happens. It's not recorded. Okay. But Sabin says such a title must appear of record to be marketable. Does that mean then that if you have a right to use a road that has been fully vested through adverse possession, there's no question about that, but it's not a record, that you don't have marketable title?
I'll try to answer your question, but I want to qualify.
I think your answer should be yes, you still have marketable title, but if it's no, then help us.
If one wants to convey marketable title to the easement, then one would have to obtain a judgment and record it as to a conveyance of warrantable title as to the easement.
But no, you got the 431.
Correct.
Okay, if that property is really landlocked, it's not marketable. If it was, as a factual matter, landlocked, it's not marketable. We have cases that say you got to have egress.
Well, Your Honor, landlocked is kind of a loose term, so they have
no way to get in
and
there
egress.
Unless you're a drone, okay?
Well,
so unless you're a drone, you don't have any way to get into the property, physically get into the property, other than you fly in there and you land in there.
I'm sorry, I think I'm going to disagree with you
Okay.
on something, Your Honor, and that's that I don't agree that that's a marketability of title issue. You could have a mountaintop lot that has no access except by helicopter. I'm not sure where I know one exists, but there's nothing legally that would prevent one from owning that, having the possessory rights and having their access be limited to helicopter. The fact that it would be landlocked in that sense would not be necessarily a marketability of title issue. You could have other contractual issues, which now I'm going to be hypothesizing what did someone put or not put in that contract. In this case, we have a contract that says, well, I don't even know if I want to go too much into the contract, but and I'm sorry if I'm backpedaling onto other things that you don't want me to talk about, but the seller's property disclosure statement gives them or points out to them the recorded quitclaim easement. That particular document, though, by the way, sellers or buyers counsel today is arguing as if there's some warranty from that. Line 236 of that document specifically says it's information only and no warranty whatsoever is given. Similarly, over into the contract, there's disclosure of the recorded easement on the addendum. But the contract itself has, I think it's around line 280, says there are no warranties except what's in this paragraph, and there's no warranty about physical access within that paragraph. So we don't have any contractual warranties that are issued here. We have only their argument that there's a warranty based upon the deed. And the deed itself, the deed of the 431 acres and the 10 acres for the Lindalls and the deed for the 13 acres for the Havens, does not say that it's conveying title to the easement. They got that easement because it was established by prescription, and that one is a vested property right that goes with the land. And they also got, in the case of the Lindalls property, the rights under the recorded quitclaim easement. But they didn't get it by virtue of it being part of that warranty deed. They got it because it's appurtenant to the title they got on the warranty deed.
You know, forgive me, but I thought there was Arizona case law, but I know there's cases from at least New York and Wyoming that say that lack of legal access renders title unmarketable.
Well, Your Honor, I don't have those cases here, but I know that what you can do is you can get title endorsements over that.
Well, let's leave title insurance out of the fray here.
Well, Your Honor, I think it's relevant to that because it maybe suggests that the reason that there is a title endorsement product available is that maybe the law is not exactly as you're asking me.
Well, I guess we'll have to take a look.
Certainly, and I may be incorrect on that as well, but I did not find those cases when I was putting together my brief here, or I would have felt like I needed to have addressed them.
I guess I'm not now clear on your argument. I thought your client's position was they had conveyed marketable title because the 431 and the 10 and the 13 were all accessible. They were not landlocked.
Oh, Your Honor, that is correct.
Okay.
We deny that the property's landlocked, and the trial judge agreed they're not landlocked. And you heard today Mr. Jacobson doesn't deny that they've actually had access the entire time.
The point you're making today is that if we just look at I'll use the 431 by way of example. If we just look at the 431, the warranty deed that went from the Lindalls to the Szynskis simply described the 431.
That's correct.
And because it said nothing about any easement, what it conveyed was marketable title to the 431. It didn't attempt to do anything beyond the 431.
It has an effect beyond that, Your Honor. It did the rights, the easement rights did go to the buyers when they got that deed. Mm-hmm. So I'm sorry if I'm being not sufficiently clear to parse that out. If we're talking about what warranties accompany that deed, the warranties only accompany the specific land described or what's described on the Exhibit A to that document. So the warranty of marketability of title that's implied in the deed only applies to the 431 acres in your example. It doesn't mean I'm saying they didn't get an easement, and it doesn't mean that they did not. They got the easement. But they don't have a warrant they don't have a warrant of marketability of title as to the easement.
I understand your point.
Well, and Your Honors, by various of your questions, you raised another point in your questions to the appellant that could have been my first issue as well, which is damage. Whether we're talking about contract claims, tort claims, any sort of claims, the last element of all those is always damage. And that was one of the issues the trial judge specifically asked about here, too. And the plaintiffs have never put on a case showing damage. They have put on experts where there's been an assumption that if the property is inaccessible, what is the value of that property? And then based on those, calculations are made. But in terms of their claim that they've been denied access, they admitted that they used the two parcels from the Lindalls for the whole 5 years they had it till it was lost to a foreclosure for non-payment of the bank loan.
And so if they believed that they were getting recorded easement, but what they really got was an insufficient recorded easement plus a prescriptive easement for the difference. Haven't they received less than what they thought they were getting?
Well, no, Your Honor. If I'll separate those out, if I may, too, though. The 431 acres and the 10 acres, they had the entire utility available of that property to them to the entire time they owned it.
Based on the recorded easement or the prescriptive easement?
Well, Your Honor, I'd say it really doesn't matter even if there was no easement. If they were never deprived of access, they had the full value of that property for the entire time they owned it. You could go back and say, what if somebody discovers after the property's transferred 2 more times that the situation they've argued in this case? Can they claim that the property was more or less valuable at the time they owned it?
Well, are you conceding then, at least for purposes of our interaction right here, that they had permissive use instead of an easement?
No, Your Honor. Mr. Jacobson, I don't know that appears any place in the record except at the time Mr. Jacobson was trying to introduce it at oral argument before the trial judge, where he was arguing that they got permission, but there was already an easement established, and there's no fact record to show that they had to get permission, even if they chose to try to make their case look better by going and asking for it.
So there was an easement. So
correct.
My question is the fact that they believed they were getting a complete recorded easement, but they only got a prescriptive easement. Have they gotten less than what they thought they were getting?
Well, Your Honor, if you may be trying to make me answer in a hypothetical fashion. I'm sorry. I'm going to answer in terms of what we have here, which is if the Stasinskis received the recorded document, which they're deemed to have had even if it wasn't handed to them, but they have it before they closed the sale, and if they believe it falls short, or even if they didn't believe it, it was their duty to find out. They have the document. If in fact it falls short, they should have not closed on the sale. By closing, they're deemed to have accepted that the easement goes as far as it shows on that record. So they don't have the ability to come in later and say, we have now realized 4 months after we lost the properties that easement fell short. We don't think we got what we were supposed to.
Well, but is your argument, though, at bottom, that there are no damages because there is no difference in terms of ingress and egress between a recorded easement and a prescriptive easement?
I agree with that, Your Honor.
So
my argument, though, was broader. I'm not sure you were agreeing with me, but my argument is they, in fact, were never denied access, never denied ingress or egress the entire time they owned those 2 parcels, and therefore they had no damage, even if there had been no prescriptive easement and the recorded one does fall short, they weren't actually damaged during the time they owned those properties.
And I guess my only quarrel with that is if they didn't get access because of the easement, then they would have to get access based on a sufferance of Mr. Moore, which would make the property unmarketable.
Well, Your Honor, I don't agree that makes it unmarketable. I understand Judge Norris's question, though, that she believes or is suggesting that there may be cases on whether that would still make it landlocked, but that's not the facts we have here, and no one's ever challenged that easement. And you know what Mr. Jacobson's proposing is basically a rule that would require people who have no dispute over country roads that have been used for years to all run into court and file lawsuits to establish easement rights. These easement, the law is that once it's established by adverse possession, it exists and it's a vested property right, and that happened here. And in fact, we have in the record a letter from Mr. Moore's attorney showing that there isn't any dispute. He's not claiming anything to the contrary.
What about Mr. Jacobson's point that around 2006 or so there was a potential buyer who backed out because he had some concerns over the easement?
Well, Your Honor, I'm not familiar with that unless it's the same party that bought at the after the foreclosure sale.
I can't remember the gentleman's name, but
well, I heard him today refer to Mr. Latardo
that was
one of the experts.
Yeah, and
right.
there is in fact a reference in, I think it's by Mr. Latardo, that the possible buyer, who shall not be named right now, thought about buying it for a big amount of money, a large amount of money, and then decided that he was a little somewhat concerned over the state of the access.
Well, Your Honor, that didn't come out of plaintiff's evidence, and there really isn't anything else to support that. But I'd also point out that if I take the other party that did buy it the foreclosure, it's in the record and undisputed that they got title insurance of physical access to the property.
But wouldn't there be possibly damage if there was a potential buyer who backed out because of concerns this was only prescriptive and not of record?
Well, Your Honor, the plaintiff would have to show quite a bit to show that was a transaction. They actually had either a contract or an offer that they could have accepted to establish that, as opposed to the suggestion that somebody might have been interested.
If there's evidence in the record that meets that standard, then is there, at least for purposes of summary judgment, a jury question or a question of fact on fact of damage?
I'm sorry, Your Honor, I'm not willing to concede that because I really don't remember what's in Mr. Latardo's attachment, and I feel like I'm going too far out on a limb.
Well, didn't Mr. Latardo's attachment come up for the first time in the motion for reconsideration?
I'm sorry, Your Honor, I don't recall, and I don't remember if Mr. Jake, it would, because my argument is that those certainly were not before the court at the time the summary judgment was
I
granted.
think it was Exhibit 9 to the motion for reconsideration, and if that were true, that wasn't before the court at the time it ruled.
Correct, Your Honor.
Thank you. Your time is up. We're going to give Mr. Jacobson 2 minutes.